Okay. Okay, everyone. For those that don't perhaps know me, I'm Marty Schuler with the OMCA, and very pleased that we're able to host this webinar today in conjunction with Miller Thomson, who have kindly come forward to help us out on this subject that everybody has a lot of, it's a hot issue right now, I guess is maybe the best way to put it. So just so that you will know, I appreciate if you would all please keep your microphones muted through the presentation, because it does help on any feedback, and make use of the chat session. I'm going to be monitoring any questions that are perhaps not covered in the presentation, or if you have something in addition. And our presenters today, Ina Koldorf and Michael Cleveland, as I say, who have generously come forward to give their time to us today to get this underway. So Ina, I'll turn it over to you.
Thank you, Marty. I'm just going to share my screen again. How's it looking on your end? Can you see my slides?
It's good. Yep.
Perfect. Okay. So hello, everyone. My name is Ina Koldorf. I'm with Miller Thomson LLP in the Labor and Employment Group in Vaughan. And my co-presenter today is Michael Cleveland, who's also a lawyer in our Labor and Employment Group in Toronto. And I think that we've all grown a little weary of the circumstances that we've dealt with for the last 15 months or so. But with the vaccine rollout finally gaining some ground, I'm hoping that hope is on the horizon for everyone. And with the government's new 3-step plan, most businesses, it looks like, will be open at some point between June 14th and the end of the summer. So this is a good time for everyone to start planning about return to work if you have any employees off work, or if your business is closed at the moment, and working towards having the business fully reopen. I'm trying to get the next slide. There we go. So here's what we're going to cover today. We are going to talk about the most common vaccination questions, how to deal with mask refusals. We're going to briefly talk about the Putting Workers First Act, which was implemented last month. Those are the paid sick leave days that were implemented by Ontario. And we're going to wrap up with adopting to the remote workplace if you will have any employees who are working remotely. So that's the game plan. If you have any questions throughout, please put them in the chat. We'll try to monitor them as we go along, and we'll try to answer them at the end if we have time, and we have left some time for that. So the most common vaccination questions, and the one that we're being asked the most, not surprisingly, is, can we require employees to get vaccinated? That is the big one. So the short answer to this question is no. An employer cannot at the moment get employees or require employees to take the COVID-19 vaccine. Ontario is actually unique in having vaccination requirements for specific workers outside of the COVID-19 context, including daycare workers, long-term care workers, and paramedics. And these legislative requirements are typically motivated by safety concerns that arise from heightened risk of transmitting communicable diseases to at-risk individuals. But the provinces and the federal government have repeatedly stated that they will not make COVID-19 vaccination mandatory, at least not for now. Employers across Canada have a legal obligation under occupational health and safety legislation to provide employees with safe workplaces and to take all reasonable precautions to protect employees from getting a work-related illness. And while implementing COVID-19 vaccination policies may be one effective way of doing that, this doesn't mean that a vaccination policy will be necessarily justified for every workplace. The ability to make vaccinations mandatory, or a mandatory condition of employment, depends on a number of factors, including the level of the risk of infection and transmission, either to employees or to others who enter the workplace, to customers, to clients, and so on. Non-healthcare employers can strongly recommend that employees get vaccinated, but at the moment can't require them to do so. And that's true even in healthcare settings. Employers cannot implement at the moment mandatory employee vaccination policies unless legislation requires it. And at the moment, there is no legislation that requires it for COVID-19 vaccines. What we are seeing healthcare employers at least do right now is move people around. So those who refuse vaccines will be moved around to non-public facing positions, for example, where they don't have to interact with the public or with customers or with clients or with patients, or they're being put on leave if there is no such position. But I think the thought behind it is that in most workplaces, voluntary vaccination, social distancing, wearing masks, and washing hands may be sufficient protection for employees, making it difficult to justify a policy mandating vaccinations. So if you do end up implementing a mandatory vaccination policy, and despite the fact that right now you can't do so, some employers do, here are the legal risks that you should consider. In a workplace that doesn't already have a mandatory vaccination requirement prior to the pandemic, an affected employee would be entitled to take the position that they have been constructively dismissed if a mandatory vaccination policy is unilaterally implemented by the employer. And this is because, like with all constructive dismissal situations, you as the employer will be imposing a unilateral substantial change to the employment contract, which in common law may be equivalent to terminating the employee, and that would give rise to common law damages. A mandatory vaccination policy may also open your company up to human rights liability. A policy may be found to be discriminatory if it doesn't include exemptions for protected grounds, such as disability, both mental and physical disability, gender, or religion. And by gender, I mean pregnancy, for example. So depending on your company and the industry, you may be able to defend a mandatory vaccination policy on the basis that it is a bona fide occupational requirement, but that threshold is also high. And even when there is a bona fide occupational requirement, an employer still has a duty to accommodate an employee who refuses or is unable to take the vaccine because of human rights protected grounds. So in other words, you will have to permit those employees to work to the extent possible, unless doing so would cause your company undue hardship, which is a very high threshold to meet. So that's the human rights risk. Another key challenge in establishing or enforcing a mandatory vaccination policy is that it's going to be difficult for an employer to establish, outside of the healthcare context probably, that existing health and safety measures are insufficient to ensure the safety of employees in any given workplace. And we're talking about what we've been doing all of this time: masks, hand washing, social distancing, and so on. There's also insufficient guidance from public health officials on whether the vaccine prevents asymptomatic transmission of the virus to others, which is another barrier to successfully arguing that mandatory vaccination is something that should be implemented. And finally, there's also some privacy issues to think about. And I put a question mark beside privacy because we don't have privacy legislation in Ontario. But as an employer, you should still ensure that you're only collecting, using, and disclosing personal information only if it is reasonably necessary to do so, and only if you actually need it to manage the workplace. And of course, there's the obvious issue of forcing your employees to undergo a medical treatment, which a vaccine really is. So mandatory vaccinations raise a host of issues. The next question we're asked quite often is, can we make vaccination mandatory for new hires? So we may not be able to force those that we have on staff already, but can we require those who we don't have on staff yet to get vaccinated as a condition of employment? And again, the short answer is likely not. Human rights laws protect candidates for employment in the same way that they protect employees from discriminatory conduct. So like with policies regarding employees, a mandatory vaccination policy for your candidates will have to exempt all those who have a human rights related reason not to get the vaccine. Again, any disability, any illness, pregnancy, religion, and so on. And so what may happen in the process is that when you ask that question of the candidates and they say, well, no, I'm not vaccinated and here is why, and they give you a human rights related reason, if you end up not hiring them, they may file a human rights complaint, and it'll be your onus to show that you didn't refuse the job to them for a reason, that you refused the job to them for a reason that's completely unrelated to the fact that they're not vaccinated because of human rights grounds. So it can get quite complicated. The risk is quite high that you'll get a legal proceeding on your hands. So it's not something that we recommend at the time. Do we have to give employees time off to get vaccinated? Currently, Saskatchewan, BC, Alberta, Manitoba, and Ontario all have legislated paid time off work for employees to get vaccinated. In Saskatchewan, BC, Alberta, and Manitoba, employees can have up to 3 paid hours off work to get vaccinated. In BC, an employee can also take an unlimited unpaid time off work to take a dependent to get vaccinated. In PEI, an employer can apply to be reimbursed for up to 3 days of wages per vaccination if the employer provides paid leave to the employees to get vaccinated upon some conditions that have to be met. And Nova Scotia has similar program but reimburses employers for up to 4 days of wages. In Ontario, as you probably all know by now, after months of pressure, the Ford government implemented the COVID-19 Putting Workers First Act early last month, and Michael is going to give you some information about it in a few minutes, but suffice it to say for now that yes, Ontario does have a mandatory vaccination leave legislation. If we can't require employees to get vaccinated, how can we encourage them to get vaccinated, which is probably your best bet at this point? We found that offering employees incentives, like with most things, get them, a lot of them to go get the vaccine. We just talked about one of those incentives, paid time off work. And although now in Ontario, you're required to pay employees time off work for up to a certain amount per day, the legislation does cap it at a certain amount per day. So if your employees make more than that amount per day, for example, as wages, you can choose to pay them for the full day above and beyond what the government requires. You can also offer such things as reimbursement for their transportation costs to and from the vaccination site and those sorts of things. Really, any incentive that you can think of that would get them to take the step to get vaccinated. Another option that we've seen some clients choose is the good old cash or gift card option. That's a great option because employees, like the rest of us, love to get some cash in their pocket. And so this is a simple incentive. You get vaccinated, you show me the email, the confirmation email after the vaccination, and I'll give you a $100 bonus or a gift card to a local business or something like that. I would just caution you, there's a bit of a human rights risk with that. The risk is quite low, but if you have an employee, for example, who can't get vaccinated for medical reasons, and they would want this incentive as well, then you may have an issue you have to deal with. But I think that issue can be mitigated with a little bit of thought. Another option is a group incentive, and we've seen larger employers do that as well. For example, you set a target of 80% of your employee population being vaccinated. When that threshold is reached, then all of your employees receive a small incentive as a group. And peer pressure helps in that case. Sometimes you have a vaccination champion who really feels strongly about vaccinations amongst your employees. So as a group, if they talk about it and you encourage that, they may convince some people who were hesitant to go get vaccinated. Can we ask employees to show proof of vaccination? So far in the pandemic, it's been perfectly acceptable to inquire into an employee's travel history, possible COVID-19 symptoms, and whereabouts during the outbreak. And these types of inquiries have been reasonable to ensure workplace safety. So I think that asking employees to disclose their vaccination status is likely to be just as reasonable for the remainder of the pandemic. You just have to be mindful of how you collect, use, and disclose this information. So you will need to collect only the minimum amount of information possible in order to address the workplace safety concern. So for example, with vaccinations, you will ask to see the confirmation email that they've received, but you won't keep a copy of it. You can just put a check mark in whatever database you're keeping, or put a note in the employee file to say, I've seen it, they've been vaccinated, we're good. Could we be liable for complications of vaccination if we mandate or encourage employee vaccinations? And generally speaking, vaccines are administered by a third party. So you as the employer will face relatively low risk of liability if you don't mandate vaccinations. Simply encouraging employees to vaccinate is not going to attract liability in all likelihood, or providing them with educational resources. Again, if you mandate vaccinations, your risk increases. The federal government not too long ago announced a countrywide no-fault vaccine injury compensation program, but the scheme is not yet operational, and we don't really know many details about it, but that's on the horizon. In April, Ontario also announced that it's going to be working with local public health units, business groups, and large employers, exploring employer-operated on-site vaccination clinics. And the idea is that you will be setting that up on your premises and offering it to your employees and to residents in the immediate area where your business is. These types of clinics are great, but I think they're going to probably increase your liability as an employer if there is some sort of reaction from an employee. But keep in mind that the WSIB indicated that where there is a strong employment connection between the immunization and the employee's job, so for example, where you're offering these clinics at your workplace, an adverse reaction may be found to be a workplace injury, and so the employee may be covered by WSIB. So those are my most common questions about vaccinations. I'm going to turn it over to Michael to speak about COVID-19 Putting Workers First Act. Michael?
Great. Thanks, Ina, and thanks everybody for having us today. So, if you could advance to the next slide, please. So as you all likely know, on April 29th of the 2021, the Ontario government amended the Employment Standards Act to require employers to provide employees with up to 3 days of paid leave for reasons related to COVID-19. And as Ina mentioned, this program is known as the Ontario COVID-19 Worker Income Protection Benefit. Now, the program is retroactive until from April 19th, 2021, and it's slated to remain in effect until September 25th, 2021, subject to further extensions, with the idea that it's a temporary leave implemented as vaccinations progress and hopefully COVID cases decline through the province. So what we'll do today is we'll walk you through the specifics of the program and provide a bit of follow-up information addressing some of the questions that employers had upon the initial rollout of the program. So great, thanks, Ina. So in terms of eligibility for the paid leave, only employees who are covered by the Employment Standards Act are eligible. So this means that if you have individuals who are employed as, or not employed, who are engaged as independent contractors or are part of a federally regulated industry, those employees would not be eligible for this type of paid leave under the Employment Standards Act because it pertains only to provincially regulated businesses. Additionally, employees who already receive paid sick time through their employer are not entitled to the paid leave. And there's some specific details about this, which I'll go through. And in terms of how an employee can indicate to their employer that they need to take the leave, it's written in the Act that a doctor's note is not required in order to be eligible for the leave. And so an employer cannot require a doctor's note as a condition for taking a leave, although they are entitled to request information that's reasonable in the circumstances, in timing that's reasonable in the circumstances. So it will essentially be a case-by-case exploration of what it's reasonable to request, but you are not entitled to request a doctor's note from an employee. Now, the program operates as a sort of a mechanism where the employer pays the employee, and there's a reimbursement to the employer. So when the employee takes a day of paid leave, the employer makes the payment on the next payroll, and then the employer goes and obtains the reimbursement from the WSIB. So the idea is that there's not as much of an interruption in the employee's pay as there might be if they were required to apply to a program separately. So the onus is placed upon the employer to then apply for reimbursement. Now, the benefit is limited to $200 a day, and employers will only receive reimbursement for up to this amount. If the employee's wages are that they would earn in a normal day are less than $200, then that's what the employee would receive, and the employer would be eligible for reimbursement at the employee's regular rate of pay. There is a time limit on applying for a reimbursement, so they are requiring employers to apply within 120 days of the paid leave. I think I'll just flag here that there is a federal paid, so the way that this discussion, it was sort of framed in the news a lot as a discussion of the federal government is currently providing a sort of a paid sick leave program called the Canada Sickness Recovery Benefit. And that's a program where employees can apply where they're off work for more than half of a work week. they can apply for a reimbursement of $500 or something in that range. But the reason that this program was devised to sort of fill in the gap was that employees who had to take maybe one day off to go get a vaccination, or those shorter term absences, maybe to go get a COVID test, they weren't able to apply for the income replacement program that the federal government had provided. So the idea is to sort of have these 3 paid sick days under the province as a temporary short-term program, but individuals who maybe require longer periods of time for quarantine or similar would be entitled to apply for the federal program. Now, for clarity, the employees apply for the federal program, so that's something that's sort of independent from the employer, whereas the unique thing about this provincial program is that it's the employer who's providing the benefits to the employee and then seeking reimbursement from the WSIB. Now, when the program rolled out, they hadn't actually implemented the portal for the WSIB reimbursement process. So there was a bit of confusion over, okay, what do we need from employees? What do we need to sort of keep on file? And thankfully now there's been a bit more direction, and the WSIB portal is open. If you do navigate to the WSIB site or the Ontario page on the worker income protection benefit, they do helpfully set out some of the information you'll need, and that will include basic things like your business number and trade name and your CRA number. If you're with the WSIB, you'll need documents pertaining to that, such as your premium remittance statements. And in terms of the individual employees to whom you provided benefits, you'll need details of any current paid sick leave coverage already available to the employees, including the number of days of coverage that they have, the daily dollar amounts of that coverage, and policy documents relating to that existing coverage, because they're going to undertake some sort of determination about whether there was eligibility to take the leave. And as part of that process, employers will also have to complete an attestation, essentially confirming that the payment was made in respect of circumstances that an employee is eligible to take the COVID leave for, and specifies things like the date on which the leave was taken, when it was paid, and confirms that there wasn't an existing entitlement as of April 19th for that employee to take paid leave under an employment contract. If you could move to the next slide. Oh, actually, I think maybe I'm one ahead. Okay, thanks. Okay, so another point of confusion that some employers had at the initial rollout of the program was that it was not entirely clear what happened in cases where an employee did have a contractual entitlement to a paid leave. Say they were given 5 paid sick days per year, but where they had already used up that entitlement prior to the 3 paid sick days coming in on April 19th. So there was some uncertainty about, okay, they do have a contractual entitlement, but they've exhausted those days. So do they get to top themselves up to 3 more days? Or is it just because they had that entitlement, they're not entitled to these further days? So after a bit of confusion and reaching out to the government to get some clarity, they have clarified now that the relevant inquiry is whether the employee had that entitlement as of April 19th. So if an employee had this 5 days of paid leave entitlement under a policy or contract, but as of April 19th had exhausted all of those days, then they are entitled to those additional 3 days of paid infectious disease emergency leave. So in order to sort of figure out whether an employee, so as I mentioned before, if an employee does have a contractual entitlement as of that date, then their entitlement to infectious disease emergency leave will be reduced by the amount of their entitlement. So if they're entitled to 1 paid sick day on April 19th going forward, they would get that 1 contractual day plus the 2, they would reduce their ESA entitlement from 3 days to 2 days. So essentially the employee, there must be 4 conditions in order to, for the employer to say, okay, your entitlement under the ESA is reduced because you already have a contractual entitlement. So First one is just that they have to be able to take that leave for the same circumstances that they would be taking the ESA leave for. That leave can't have been used up, as I mentioned. And the pay that the employee would receive needs to be the same or greater that they would have received under the ESA leave. And finally, the conditions for taking the leave can't be more restrictive than what's provided in the ESA for taking the leave. So when all of those conditions are met, then that's a situation where the employee's entitlement to the ESA leave would be reduced by the amount of days that the employee is already contractually entitled to. And moving on, I will go into a bit of an aside on this whole area of infectious disease emergency leave and how it's interacting with layoffs and constructive dismissal, because we're starting to see court decisions that are coming through from which originate out of the start of the pandemic. So when you looking back at March and April 2020, when there were many layoffs across many industries due to public health orders and large-scale shutdowns at that point, a lot of industries implemented widespread layoffs, and a lot of those, the litigation arising out of those initial layoffs is now we're finally starting to see some decisions and analysis of how those layoffs operated in terms of whether employees were constructively dismissed and were entitled to damages in respect of the layoff. So it's an area that we'll see develop more as this jurisprudence kind of comes through after 15 months of wondering how it will turn out. So for background, the infectious disease emergency leave regulation was implemented at the onset of the pandemic, and it provides essentially that during the COVID-19 period, non-unionized employees are deemed to be on a job-protected emergency leave if the employer has temporarily reduced their workforce for a reason related to COVID-19. And so currently this COVID-19 period, it started on March 1st, 2020, and it's been extended a number of times. It currently set to expire on July 3rd, 2021. It is subject to potential further extensions. Now, another important part of this regulation is that Section 7 provides that temporary reduction or elimination of an employee's hours of work by the employer for reasons related to COVID-19 does not constitute a constructive dismissal. One of the first cases that really dug into this issue is Coutinho and Ocular Healthcare. And this was released early in May. So the background is that Ocular operates ophthalmology clinics and has a clinic in Cambridge, Ontario. The plaintiff was employed at Ocular's Cambridge clinic and earned an annual salary of $50,000. She'd started at the clinic in 2014 as a technician, and she'd since been promoted to a management position. In April 2020, when COVID was really picking up steam, the owners of Ocular were embroiled in a dispute with two of the doctors at the Cambridge clinic regarding various corporate and business issues. The owners of the clinic were also frustrated by the fact that the Cambridge doctors weren't complying with physical distancing rules that had recently been implemented. So on May 1st, 2020, the employee showed up to work at the clinic, and she was met by one of the owners who told her that the clinic was closed and that she was not permitted to enter. Later that day, she received a voicemail message from one of the owners advising that the clinic was closed, but that she would be paid until further notice. On May 29th, the owners of Ocular wrote to the employee to advise that Ocular had been forced to close the Cambridge clinic, in part due to concerns related to physical distancing practices, and was required to temporarily reduce its workforce. Ocular advised that the employee was being placed on temporary layoff and that it would do its best to recall her as soon as possible. On July 22nd, after being laid off for 7 weeks, the employee became re-employed by Ocular at a different clinic and actually was earning more than she had previously earned at the Cambridge clinic. But before that had happened, on June 1st, 2020, she had commenced a claim against Ocular, alleging that she'd been constructively dismissed, and she sought $200,000 in damages. So in defending against the action, Ocular pleaded that the employee, she had not been constructively dismissed because she was deemed to be on this infectious disease emergency leave pursuant to the regulation that we reviewed. because the reduction in her hours was related to the COVID-19 pandemic. Ocular, based on this defense, moved for summary judgment to dismiss the employee's claim on the basis that the plaintiff was deemed to be on emergency leave. And the key issue for the court to determine on this motion was whether the infectious disease emergency leave regulation precluded a claim for constructive dismissal under the common law. So the key thing to note is that there's a provision in the Employment Standards Act which states that no civil remedy of an employee against his or her employer is affected by the act. So that's when we think about Section 7 of the regulation, which says that an employee is not constructively dismissed for when they are placed on an infectious disease emergency leave, then that runs up against the provision in the ESA, which states that nothing in the Act, which includes the infectious disease emergency leave regulation, can affect a civil remedy of an employee against the employer. So in considering this issue, the court looked at Ministry of Labor publications, which also seemed to clarify that the regulation was only affecting what constituted a constructive dismissal under the Employment Standards Act, so under statute, but not at common law. So looking at this, the court dismissed the motion for summary judgment and found that while the regulation prevented a claim for constructive dismissal under the ESA, so the employee hadn't been constructively dismissed under the ESA, it didn't take away their ability to pursue a claim for constructive dismissal at common law. So the employee was entitled to still treat the unilateral imposition of a layoff as a termination of employment at common law, and therefore the plaintiff had an immediate right to sue for constructive dismissal and damages. Now, because the employee had obtained reemployment after 7 weeks, actually at a higher salary, the court noted that she had fully mitigated her damages, but it nevertheless ordered Ocular to provide the employee with her statutory minimum entitlements under the ESA to the sum of $6,000. So this is the first case in Ontario that's considered the impact of the infectious disease emergency leave regulation. And we're very likely to see further litigation on the issue, given the number of people who were laid off at the beginning of the pandemic. Now, with respect to the court's holding that infectious disease emergency leave doesn't preclude a claim for constructive dismissal at common law, this seems to largely be a correct interpretation of the law in light of Section 8 of the ESA. But where the court seems to have maybe gotten it wrong is awarding the employee her statutory ESA entitlements. So as we flagged, the infectious disease emergency leave, the function of it, the regulation, is to state that being on such a leave doesn't amount to constructive dismissal under the ESA. And yet what was awarded as damages were the employee's statutory termination pay entitlements, when really, because the operation of the regulation should have precluded entitlement to that. So we think it's an interesting case. It's unclear whether this one will be appealed further, because ultimately the judgment was for in the range of $6,000. So it may not be something that is appealed, but it certainly may arise in other contexts, and we may see further clarification. So we would definitely encourage you to keep an eye out for developments on this front. Moving on to another case. So in this case, Korma was a manufacturer that manufactured a variety of corrugated tubing and just a variety of manufacturing operations that depended upon China for key supplies. So lots of shipping coming from abroad. So in late 2019 and early 2020, the outbreak of COVID-19 in China, before it had really disrupted operations in Ontario, had already had a very significant impact on the company's supply chain and had caused a decline in revenues upwards of 40%. So in reaction to this, Korma temporarily laid off 17% of its workforce because it was facing delays in orders. And as part of its layoff notice, it cited the unstable political climate at the time. And important to note that the company had no history of placing employees on temporary layoffs. So at the time of both of these layoffs, there was not the infectious disease emergency leave regulation in the ESA. So this predated that because it was sort of one of those instances where the company was affected before it really arrived in Ontario, before COVID really impacted Ontario directly. And what Corma argued was that in response to a constructive dismissal claim, they argued that the pandemic is a once in a lifetime occurrence. And it's such a dramatic and drastic event that had the parties actually turned their mind to it when the contract was first entered into, they would reasonably have agreed to permit a temporary layoff to safeguard the ability of the employer to rehire employees when the situation improved. So essentially saying that there was an implied term in the contract that when a dramatic unforeseen circumstances arise, that there was the employer had permission to temporarily lay off the employees in order to preserve the business. Now, the court was somewhat skeptical of this argument and ultimately did not agree with it. But the reason we flag it is it's because this is a situation that many employers faced at the start of the pandemic, was just massive uncertainty about not only massive uncertainty about the future of the pandemic, but also facing significant public health restrictions, which in many cases forced employers to shut down. So looking at these facts, the court found that without the benefit of hindsight, there wasn't much to distinguish the situation in early February 2020 from other significant events like bankruptcy or recessions, which, while those are dramatic events and can significantly disrupt business operations, they've never justified unilateral layoffs. So looking at it from only situated at February 2020 and not knowing what the future held, it wasn't a sufficiently disruptive event, even though, again, their revenues had declined by 40% by that point. It still did not sort of engage this. I think the court sort of put a damper on the idea that by that point it had already become a quote once in a lifetime experience. And the reason the court likely did that is, to some extent trying to make it a specific, not trying to generalize too much, because there's going to be future litigation where layoffs did occur sort of in the midst of the pandemic, and maybe the court was a little bit hesitant to rule on those instances. So more confined to layoffs that occurred just before the pandemic. The court, as part of this, declined to determine whether it might be reasonable to imply some sort of quote force majeure clause in the case of a business which is prohibited from operating or placed under severe operational limitations by government action. So maybe leaving the door open to situations where there's maybe a closure order or similar, rather than just shutting down because of business uncertainties. But that's something that wasn't determined in this case. And the circumstances which were existing when these plaintiffs were laid off did not reasonably lead to the conclusion that the parties would have mutually agreed to allow an indefinite layoff and to be imposed upon the employees. But essentially saying, even if the employees had turned their minds to the situation of an employer suffering significant headwinds, they wouldn't have agreed to say that they were permitted to be laid off with minimal compensation. And so the second prong of this, which undercut the employer's argument, was that even if there was such an implied term, since the layoff extended beyond the 35 weeks that is permitted in the Employment Standards Act, it was deemed to be a retroactive dismissal by operation of the Employment Standards Act, and thus that implied term would have been in violation of the ESA and therefore void. So again, that's somewhat a product of having been implemented prior to the infectious disease emergency leave, but something to think about to the extent that any employers did implement layoffs prior to that date. So the key takeaway for that is that case is that absent agreement to the contrary, an employer's unilateral action in laying off an employee, even in significantly adverse circumstances, represents a material change in the terms of employment that the employee can elect to treat as a constructive dismissal. Great, and I will talk a little bit about mask refusals and human rights. So in the case of Sharma and Toronto, this is a case not strictly in the employment contract, but in the employment context, but it does deal with mask bylaws. So there was the City of Toronto implemented a bylaw which required businesses and other establishments to adopt a policy requiring members of the public to wear a mask or face covering when entering. And the applicant argued that the city discriminated against him with respect to services on the basis of creed and disability, contrary to the Ontario Human Rights Code. The applicant brought this application on the basis that he had been harassed, lectured, and turned away and denied service at a number of businesses throughout the City of Toronto for his failure to wear a mask. And with respect to the alleged discrimination on the basis of creed, Mr. Sharma argued that his creed disagreed with him covering his face for, quote, unsubstantiated claims. He argued that the city's claim that masks prevent the spread of COVID was not substantiated by scientific evidence. And he said that his creed required that he not blindly accept what government mandates, what the government mandates or puts into law. With respect to the alleged discrimination on the basis of disability, Mr. Sharma argued that his breathing was impaired by wearing a face mask due to a medical condition, though he did not disclose the nature of his medical condition in the application for privacy reasons. He did disclose the particulars to the tribunal, which was satisfied that there was medical conditions involved, but was not disclosed in the decision. The tribunal looked at whether the two protected grounds for discrimination alleged had been engaged by the code, and first found that creed had not been engaged because the applicant's opposition was based on the basis that the mask mandate was not evidence-based. The tribunal held that creed, while it's not defined in the Human Rights Code, most often engages an applicant's religious beliefs and practices, but does not include political opinion. So the applicant was objecting on the basis that it was not evidence-based, and that did not engage creed within the meaning of the Human Rights Code. The tribunal did find that disability had been engaged because the onus, although the onus was on the applicant to provide the specifics of his disabilities that he says impaired his ability to wear a mask. Again, the tribunal was satisfied here that he did suffer from medical conditions which impaired his ability to breathe. However, ultimately, the application was dismissed because it had no reasonable prospect of success. The applicant had only named the City of Toronto as the respondent, but the discrimination that he was alleging was at the hands of various businesses in the city who were following the city's mask mandate. Essentially, the tribunal said it was open to the applicant to bring applications against each of the businesses who allegedly discriminated against him in applying the mask mandate. However, there was not discrimination on the part of the city. In another case, this is a BC decision. The reason we're citing a BC decision is that we're not aware of currently any Ontario decisions that have considered the human rights consequences of mask mandates in the employment setting. But the BC Human Rights Tribunal's decision does set out some principles which we think are certainly applicable in Ontario. So for background, the reason this decision is called the worker and the district managers is that for privacy reasons, the BC Human Rights Tribunal didn't release the identity of the worker or the respondent in this case. But we do know that the employee was contracted to do work at a district facility. And when he arrived there, the manager told him that he had to wear a mask and that he could not enter the facility without wearing one. The employee refused to wear a mask on the basis that his religious creed prevented him from doing so. The senior manager of the facility subsequently sent a letter to the employee terminating his contract for his refusal to wear a mask. And this, because it was a screening decision, this is a situation where the tribunal was just considering a threshold issue. They weren't determining the merits of the case, but they were determining the threshold question of whether the worker had alleged facts that, if they were proven to be true, could be a contravention of the BC Human Rights Code. Based on the case law regarding discrimination on the basis of creed, the tribunal held that the worker was required to set out facts supporting his religious belief, and that the respondent's conduct had an adverse impact on him regarding his employment, and that his religion was a factor in the adverse impact. In looking at whether the worker's refusal to wear a mask engaged his religious belief, the tribunal observed that the protection of religious belief or practice is triggered when a person can show that they sincerely believe that the belief or practice has a connection with religion or is experientially religious in nature. In this case, the worker stated that his religious belief had been engaged because, quote, "We are all made in the image of God. A big part of our image that we identify with is our face. To cover up our face arbitrarily dishonors God." The worker also stated that he did not believe that mask wearing was effective, and given that forced mask wearing does not help, in his view, protect anyone from viruses, quote, "I cannot live that lie." The tribunal held that the worker could not point to any facts that could support a finding that wearing a mask is objectively or subjectively prohibited by a particular religion. The tribunal stated that the worker's objection to the mask mandate was based on its alleged arbitrariness. Quoting another tribunal decision, the tribunal held that the code does not protect people who refuse to wear a mask as a matter of personal preference because they believe wearing a mask is pointless, or because they disagree that wearing masks helps to protect the public during the pandemic. The tribunal therefore dismissed the application as it did not set out a possible contravention of the BC Human Rights Code. So these cases, some takeaway from these cases is that a belief in the inefficacy of masks will not generally attract human rights protection. Both of the cases we reviewed show that in order to engage creed, an objection to a mask mandate or policy needs to be grounded in a religious belief or practice, not simply a political belief. So for employers, this means that employers can enforce compliance with mask policies where the employee's objection is limited to their political beliefs or a belief that masks are ineffective. No duty to accommodate would be owed in those circumstances. Although with respect to what accommodation is required when an employee refuses to wear a mask due to a medical condition, we would recommend that employers treat this like any other accommodation request. Medical documents should be provided by the employee and by their treating physician, which confirms that wearing a mask is not required, or not wearing a mask is required because of the employee's medical condition. While employers cannot ask specifically what the medical condition is, they can ask about what it is about the medical condition that causes the restriction. So if you're faced with the situation as an employer, then you do have a duty to accommodate, but not at the expense of other employees' safety. There are many accommodation options that are available in the circumstances, such as having the employee work from home or having them work in an enclosed space where they cannot transmit COVID to others. The bottom line and the key takeaway, I think, is that with respect to accommodation, every situation is different and very fact specific. With that, I will turn it back to Ina, who's going to speak a little bit about adapting to the remote workplace.
Thank you, Michael. I actually can see the chat because I'm sharing the screen. Are there any questions in there before I move on?
Oh, yeah. So we've got two questions. So first one is, what is the standard if a customer refuses a mask for a medical condition? Can they be asked to wear a mask or return when masks are not mandatory? Are they required to provide proof of their medical condition? So in terms of, I don't know if you've dealt with the situation of customer refusals. I know it can be a little bit different from employers, but I think I would say my view is, again, you're dealing with a fact-specific scenario. You generally do still have a duty to accommodate as a service provider, but what that will look like may be somewhat different than in the employment context. I don't know if do you have any sort of specific advice for employers in this context?
Yeah, I would, and I know that there have been some releases from the government on this over time, especially when mask wearing started being mandated earlier on in the pandemic. Most customers now know if they can't wear a mask, they have some sort of medical documentation on them to show. So that's the first thing. You can ask for medical documentation. It's not going to tell you what your customer has in terms of a medical diagnosis. It's likely just simply going to say this person cannot wear a mask for medical reasons signed by a doctor, and that should be sufficient. So that would be your first step. Then your second step would be looking at your specific circumstances. Like Michael said, if you are, for example, chartering a bus and you have 30 people sitting on a smaller bus and the one person can't wear a mask, but everybody else wears a mask, you have to do your risk benefit analysis on whether you're putting, first of all, your employees at risk, whether you're putting your other customers at risk. If you conclude that you are, then you should be looking at denying services to this manager, to this customer. The threshold that you need to look at the end of the day is called undue hardship for your business. Is this something that your business cannot accommodate? And that would change depending on what this customer is doing in your business. So the answer is always, it depends. But first of all, you should be asking for some sort of confirmation that they can't wear a mask, and then you should see it whether you can accommodate the specific customer. It's in any way without causing undue hardship to yourself as a business and to your other customers and employees. Is there another question, Michael? And then I'm going to move on with my.
There are
Michael,
two.
Sorry, I was just going to say, if you don't mind, if I just jump in for a minute, we have a couple of tour operators who have reached out directly to me. So, and just one is looking for advice in particular. So many of our tour operators, beyond doing, local tours and day trips, they do have tours that they escort internationally over to Europe, cruises, whatever. So if they have a tour leader who's a longtime employee who has normally done a lot of this, accompanying groups, and is refusing to get the vaccine, what's the advice here? A lot of the European countries are saying that they want proof of vaccine. So where does the employer fall in a case like that?
So it depends on where this where this guide is going to go. If he or she is going to go to a country that requires vaccines, then there's your answer, right? They cannot be on that tour. They cannot go to that country. If it is more local, you again have to look at whether you are able to keep a safe social distance between that person and everybody else around them. Like, use the guidance we'll be getting from the health table this entire time, the mask wearing, the social distancing, and the hand washing. Those are kind of your health and safety obligations at the moment. And if you think that those obligations aren't enough to protect everybody around this person and the person, him or herself, then you will have to first try to see if you can change their job to enable them to distance themselves from others and to keep them safe. And then maybe talk about not having them in the same position with other people. You really do have to work with them. You cannot simply terminate them or discipline them just because they're refusing to get the vaccine. You have to see whether you can accommodate that. The other thing I would look at is why, right? I mean, some people are just vaccine hesitant, and others have actual reasons. If they're just vaccine hesitant, it's a lot easier to deal with, because then you're not bogged down by the human rights legislation. But by bogged down, I mean you don't have those higher obligations to accommodate them to the point of undue hardship that you would if they couldn't take the vaccine because of medical reasons, for example. So I would look for the reasons as well. I would ask them why. Okay,
and if the employee cites discrimination?
Well, it depends on the basis of what. If the employee is pregnant, for example, then there is a sufficient reason not to get the vaccine right now. And you have an obligation to accommodate. If the employee has a medical condition, there should be a medical certificate saying that he cannot or she cannot get the vaccine because of a medical condition. So discrimination is kind of a very general word, but if you go into the Human Rights Code or you just Google it, there is a list of grounds under which employees can claim discrimination. It's an inclusive list. So if that ground of discrimination isn't on that list in the Human Rights Code, then it isn't discrimination.
Okay. Okay, one other question that came in, again, this is tour operator related, but a big market for our tour operators is that working with approved Ontario school boards, they're providing tours for students anywhere from 10 to 17-year-old. If the school boards make it a requirement that the tour leaders need to be vaccinated, can the employer then in turn make it a requirement of the staff? Similar to, they have to have the vulnerable reference checks done. So is that legal for the employer to be able to ask for that?
It's to an extent. You will have to move somebody around. So if somebody's refusing, if somebody's refusing to get vaccinated, but your client, your customer is requiring vaccination, then that person will have to be moved to another job. Because obviously you have to comply with that. I shouldn't say that. I would be very surprised if school boards have that requirement by September. I mean, they may in the future, but I think that they would look for guidance from the government, which right now doesn't require vaccinations of anybody. Even long-term care workers don't have to be vaccinated at this point. But if that is the case, then you would have an obligation to move that person to another job if you're able, and if not, you should talk about what to do with them at that point. But I certainly would not send them on a bus with with your contract with the school if that's what the school requires and they refuse. And they need to know that. They need to know they can't do that job because they're refusing to vaccinate.
Okay.
It's a very, the problem is it's a very complex area because you are requiring people to put something into their bodies, right? So it is considered to be a medical treatment. And so it's a very kind of fine line between your rights as an employer and your rights to run your business and your ability to require people to undergo medical treatment. Unnecessarily, some people think. So that's why this area is so complicated, and things change, by the way, week to week. Yesterday, new measures for long-term care workers with respect to vaccinations were announced, right? And next week, something else may be announced. So those are the answers as of today, but those may not be the answers next week or next month. It's just something to keep in mind.
Okay, thanks. Michael, I think there were a couple other questions in here about the federal regulations. Are you able to take those?
Yeah, so there was one question about, so the question is, if I understand correctly, there's no short-term sick days program for federally regulated employees, as the federal Canada Sickness Recovery Benefit program is for employees to apply for, and it's predicated on a longer time off work. So this is generally correct. The caveat is that there's an existing 3 days of leave, 5 days of leave, 3 of which are paid for federally regulated employees. So there's already one of the reasons I think that the Ontario government ultimately implemented the 3 days of the temporary COVID leave was to have some parity with the existing federal sick day entitlement. So that's something that predates COVID and wasn't specifically introduced in response to COVID, but is an existing entitlement to sick day, paid sick days for federally regulated employees.
I'm not going to have time, unfortunately, to go through the last section. What I did want to say about it to everybody, the last section would have been adapting to the remote workplace. And really what I wanted to say about that is just because you may have employees who work at home doesn't mean that you are exempt from the legal obligations that you have as an employer. WSIB will still apply for injuries that employees, or may apply, I should say, to injuries that employees will experience at home while they're working for your organization. You still have to abide by employment standards. So if employees are working overtime, that still counts. You have to pay them overtime, even though they're working from home. You still have health and safety obligations. So there is no reason not to do an assessment, a remote assessment of the work area your employees are in, so they don't get injured, just like you would do at your actual workplace. And lastly, just a note about mental health. We found through working with our clients that everybody experiences this pandemic differently. Some people are dealing very well with the pandemic, and some people are not. And so when it comes to bringing your employees back to work as things are reopening, the one thing to remember is that have empathy. Make sure that when you can, you accommodate employees, because everybody's kind of trying to figure out their life right now and post-pandemic all at the same time. And I think that at the end of the day, if you want dedicated employees who will stay with you for a long time, they will remember how their employer treated them during this kind of very unusual, significant time in their lives. So that's my last section in 4 breaths. Marty, I don't know if you have some closing remarks, but I want to thank everyone for joining us today. And I'm glad we had time for some questions, and I'll turn it over to Marty.
Yeah, that's great, Ina and Michael. Thank you so much. And there's a couple other questions coming in, but I can flip those over to you if that's okay, just through an email. As mentioned, this is going to be, the recording will be on the website, I'm sorry. And Ina, are you able to share your presentation so that we can distribute it?
Sure, absolutely.
Perfect. Okay. Well, I want to thank everyone for joining. I know that it was a wealth of information, and it really is a burning topic for so many people right now, and somewhat, I'm sure you can appreciate, a frustrating one. Okay. But and I like your point that it's ever evolving almost daily or weekly. So I think we just have to stay on top of it. But again, thank you so much for your time.
You're welcome. Take care,
And
everyone.
Thank you.
thank you for everybody joining.
Thank you.